Fulton County District Attorney Fani Willis and attorneys for a defendant in a Georgia racketeering case involving former President Trump will face off in court Tuesday as the state attorney general seeks to revoke Harrison Floyd's bail over inflammatory social media posts. Floyd, the leader of Black Voices for Trump who was charged along with the former president, could see his pretrial freedom revoked over social media posts that prosecutors portrayed as an attempt to obstruct justice by intimidating future witnesses and communicating directly and indirectly with colleagues. After Floyd was charged in the wide-ranging case centering on an alleged criminal attempt to overturn Georgia's 2020 presidential election results to his advantage, he is among 19 defendants at risk of arrest for posts that prosecutors allege violate pretrial release conditions which Floyd agreed. It raises questions about how Willis might approach similar concerns about Trump's inflammatory social media as a future trial looms to more. Here Trump's free speech claim will be stronger than the claims of other defendants because he is running for president, said Kay Levine, a law professor at Emory University. But I don't think that gives him the right to say literally anything in person, at a press conference, on social media or in any other forum. The posts mention known state witnesses, including Georgia's Secretary of State Brad Raffensperger and Gabe Sterling, the State Department's chief operating officer. Look, the truth is Gasek of State and Gabriel Sterling are things you should be mad at, Floyd wrote on November 7, using a poop emoji instead of a swear word. Floyd also made several posts about Fulton County poll worker Ruby Freeman, who allegedly tried to persuade him to make false statements about 2020 election operations under the guise of offering her assistance. Those posts led to renewed threats of violence against Freeman. Willis wrote in his filing, both Floyd and Trump agreed to pretrial release conditions requiring them not to communicate in any way with co-defendants and witnesses about the facts of the case. They also cannot intimidate co-defendants or witnesses in the case. Levine said Floyd's lawyer will likely argue Tuesday that Trump's co-defendants used their First Amendment right to question validity of the state's case by posting on social media and that posts were not used to intimidate witnesses. But prosecutors may argue that witness intimidation in the age of social media involves much more than visualizing knives and guns. I would expect his office to say that it is foolish to think that all he did was legitimately question the credibility of these witnesses, Levine said. Trump's lawyers have made similar arguments in other legal matters where the former president's social media habits have already created problems. Judges in both New York issued a gag order banning Trump from commenting on people connected to the case after publicatio